My name is Paul Zarling. I'm the managing partner here for Client First Tax and Wealth Advisors. And for those that have come to these before, we like to start these off with some trivia. So we're doing estate planning, and there was estate tax, there was gift tax. What year in the USA was the estate and the gift tax combined in the tax code? What year? Any guesses?
74.
1974, okay. Any other guesses?
83.
83? Anyone else?
87.
87. We're going to go with you, closest without going over. So it was 1976 in the Tax Reformation Act was when they were combined. So you had 1974, so very, very close. It's interesting when you look at the estate tax history in the U.S., it was always used to fund wars for the Revolution and then against France. Anyway, so I'm excited to introduce Rob. He's going to introduce his team. Rob handles all of my personal estate planning. He handles a lot of our clients as well. Almost 2 decades of experience. He went to Swarthmore College for his undergrad, which is near Philadelphia. And then for law, he went to Penn State, so about only 3 hours west there in Pennsylvania. We're happy to have him back in the area, coaching his kids for football or a variety of other sports. And he's going to be covering some really essential information on estate planning. And what you're going to love about Rob is he's a lawyer, but doesn't talk like a lawyer, right? He's going to really distill things down and make it really applicable for your situation. So with that, a round of applause for Rob.
Thank you, Paul. I appreciate that. First of all, can everybody hear me, most importantly? Wonderful. All right. So in front of you, you should have a thumbs up, thumbs down sign and also a handout. So while we're doing that, like I said, the thumbs up, thumbs down thing, again, this is going to be an interactive session today. It's not maybe not as interactive as our bingo session from previous times, but hopefully we'll still have a good time with it, okay? Yes, the majority of this presentation is going to be geared toward estate planning, okay? But I want to make sure we all understand the thumbs up and thumbs down concept and just have a little fun with this a little bit before we get started. So we're going to start with some tough choices here, okay? I'm going to make some statements. If you agree with the statement, green thumbs up. If you disagree with the statement, thumbs down. You ready for number one? Brett Favre is the greatest Packers quarterback of all time. Thumbs up. That's about 50-50. Those holding up red, what's your argument? Aaron Rodgers, Bart Starr, Lee Dickey? I got to admit, as a millennial, I never saw Bart Starr play. I apologize. I've seen some videos. I like what I see. I will argue, though, that Don Hudson's the best receiver in Packer history. And Sterling Sharp is the number 2. I will say that. All right? Tough choice number 2. Potato pancakes are the best side with a fish fry. About another 50-50. Okay, we got some split decisions here. Got to go to the cards like they do in boxing. What other sides do we recommend here? Coleslaw, potatoes, yeah. Totally agree. All right, let's go with number 3. iPhone is better than Droid. Where are my iPhone lovers here? There we go. There we go. We're about 2/3, 1/3 there, iPhones. Good job. Good job. Football or baseball? Football is better than baseball. Green up for football, red up for baseball. I mean, I coach football, I play college football, but I do enjoy baseball. Choice number 5. Coke is better than Pepsi. Oh, we got a lot of Coke fans in the house. A lot of Coke fans. See, in my opinion, Coke itself is better than Pepsi, but I like Diet Mountain Dew, which is a Pepsi product. So you got to throw that one in there, kind of a little curveball there. Number 6, driving is better than flying. We got some old school people. I like that. Yeah, we got a lot of drivers here. I like that a lot. I am terrified of flying, okay? I did go, those of you who were here, I went on my cruise, okay? Had to fly for that, hated it, but I did it. Driving is definitely better than flying in my opinion. Summer is better than winter. Okay, well, I'm in the minority here. I am definitely team winter. I'm a big old guy. I sweat a lot in the summer, so winter's definitely better in my opinion. A couple more here to get you guys warmed up. Dogs are better than cats. Yeah, we got some dog lovers in the house. All right, this is great. This is good. This is my kind of audience. I like this. Ketchup is better than mustard. That's about 50-50. A little few more ketchup fans in the house, but we're good. Final one. Crossword puzzles are better than Sudokus. All right, you got to turn it to the side because they're both amazing, all right? So I'm going to disagree with everybody and say that's a 50-50. They're both phenomenal. So those are just some things. So now what we're going to do is this, okay? I want to have a little fun with it. Now we're going to get into the estate planning aspect of this, all right? So what we're going to do is this. We have concocted 9 different common estate planning scenarios, okay? I've enlisted the help of my 3 wonderful paralegals here, okay? Going from closest to furthest to me, we have Stacy, Shannon, and Taylor. These are my 3 paralegals. They've volunteered, or kind of been coerced, but semi-volunteered, to serve as my actresses today to walk through some scenarios, okay? So what they're going to do is they're going to be clients. They're going to be clients who introduce an issue to the attorney. And I, as the attorney, am going to give legal advice. We will then give the audience an opportunity to determine whether or not they think that is good legal advice, green thumbs up, or bad legal advice, red thumbs down. And then I, of course, as the real attorney, will explain what the law is and what the correct legal advice is, okay? So first we have Shannon, okay? The issue of blended families. So Shannon is going to be a client coming to my office, and she's going to walk through her scenario, and I'm going to give her advice.
So, my name is Carol. I'm divorced and I have 2 children from a previous marriage. My husband Jimmy has 3 children from a previous marriage. We do not have any children together. We want to create an estate plan together, but we want it to be equal among both of our children. I love Jimmy, but I can't say for certain that he would not cut my children out of our estate plan if I die first. Is there anything I can do to make sure this does not happen?
All right, so before we get started, just a couple points. Blended families are very common, right? 52% of marriages end in divorce in this country. So blended families are becoming more common by the day. Here's my legal advice to you, Carol. With Wisconsin being a marital property state, all assets must pass the surviving spouse. What the surviving spouse does is purely up to him. We cannot control the money from beyond the grave. Green thumbs up if that's good legal advice. Red thumbs up if it's bad legal advice. Okay, we got some green, but mostly red. And again, I'm not talking about whether we like the advice, whether the advice is legally correct, okay? Because a lot of times in the law, there's things we don't like, okay? I'm not saying whether we like it or not, but is this correct legal advice, incorrect legal advice, okay? And the answer is it is predominantly incorrect, okay? There is an aspect of it that is true, and that Wisconsin is a marital property state. Let me briefly explain what that entails, okay? Because to a lot of people, it's intuitive, right? Well, of course, if one spouse passes away, everything passes to the surviving spouse. Well, as we all know, there's 50 states in the country, and about, I think, 16 of them are marital property states. The other 34 are not. All marital property states mean is it creates a presumption that all assets are marital. That presumption can be overcome based upon the conduct of the parties, how they hold assets, and if they have any documentation drafted beforehand, okay? But we can place restrictions into estate planning documents that will enable us to protect the assets from going to one side or the other. The problem is we don't have discretion about how and when that happens. The analogy I use is a water spigot. It can either be on or off. We can't turn it on or off depending on the circumstances. We either have to say, when one spouse passes away, we allocate this property to go to our children, or no property goes to the children. It doesn't have to be all property. A very common example is people say, I have a life insurance policy. Carol may have gotten a life insurance policy from her previous employer when she was previously married. She wants that to go to her children. We can do that by beneficiary designation. We can do that through the trust. It's not an all or nothing proposition, but we do have to have the estate plan defined to say that this person, the surviving spouse, cannot make changes, because you can imagine that that could be a problem, right? Somebody may say, I want this all to go to my kids. But we have to be careful, because if we put that kind of restriction in that says absolutely no changes after spouse 1 dies, what if there's a scenario where we want to make changes? And I'm going to give you 2 common examples. Common example number 1 is this. We have Carol and Jimmy, okay? What if Carol gets along wonderfully with Jimmy's kids, but one of Jimmy's kids gets in an accident and becomes a paraplegic and is receiving governmental benefits? We'd want to change the trust. to make sure that that child does not lose his or her governmental benefits when they receive an inheritance. So we have to be mindful of that. If we're going to put in a provision that says surviving spouse can't make changes, we have to understand that there's the risk that we may desire to make changes down the road. Or what if one of the children becomes very difficult after the divorce, or after the death? I've had that happen before. In fact, I've had a situation where I've had the police called to a funeral because things have not gone well between the former in-laws and the widow. Basically, the children claiming that the widow was the reason why their father passed away. Okay? These things happen. So we have to be as aware of these as possible. Okay? The other point I want to make is the question of equal. Okay? Under this hypothetical, Carol had 2 children, Jimmy had 3. You could make an argument that equal is 20% to each child. You could also make an argument that it should be 50% to Jimmy's children, 50% to Carol's children. There's no right or wrong answer, but the clients need to be aware of the disparities between the two. And what happens if one of the 5 predeceases? Does their share only go to their surviving children or surviving siblings? Does it go to their children? These are all issues that we have to be very cognizant of when we have a blended family. Finally, the other issue that I run into almost all the time with my blended families is this. Second marriage for both. They're sitting in a room with me. They're going through it. And they ask, what if I die early and my spouse remarries someone else? I don't want my money. I'm okay with my money going to my spouse, but I don't want my money going to some person who's taking advantage of my spouse later in life and marrying them. So what I tell my clients is this agreement I'm about to say may not be legally binding, but it works. I will tell them, look at your spouse right now and promise them that you will not get remarried without the benefit of what?
Prenup.
A prenup. Thank you. So again, prenups determine assets. You can have prenups. A lot of people are surprised. You can get postnups as well. Everyone's heard of the prenup, but there's also postnuptial agreements that are in place that allow you to circumvent Wisconsin marital property laws based upon the agreement of the spouse. So again, blended families do bring up a lot of issues. Do we want to restrict access after one, or restrict the ability to make changes after one spouse passes away? How do we want to treat the children that are of the marriage? Because again, this scenario, Carol and Jimmy didn't have children together. But it certainly could be the case that Carol has her own children, Jimmy has his own children, and they have a child or children in common. That can always change the analysis as well. So again, with blended families, estate planning is extremely important. I mean, it's extremely important for everybody, but particularly for blended families to make sure assets go where we want them to go. Okay? Next scenario, we have Taylor. Updating beneficiaries.
Can everyone hear me okay? Yes? Okay. My name is Roxanne. My husband Ricky and I just had our 3rd child. After our 2nd child, we decided to create an estate plan. Following the advice of our attorney, we listed the trust as the beneficiary on all of our assets, except as we were instructed, we kept retirement assets out of our trust. For the retirement asset, we have the non-owning spouse as the primary beneficiary and our children, Alex and Ben, as our beneficiaries. When our daughter Celeste was born last year, we looked over our estate plan. The attorney did not list our children by name, but rather stated that all assets would be split evenly between all of our surviving children. Therefore, we do not need to make any updates.
Thank you, Taylor. That's correct. Because your attorney had the foresight not to list all children by name, but rather a general split evenly between my children, no updates are needed. Thumbs up if that's good advice. Thumbs down if it's bad advice. Okay. There are very few thumbs down, and I kind of pulled a trick on you guys here because this is like 90% correct. Those of you who put up the red thumb, why did you put up the red thumb? Why is that incorrect?
Because you have to list your beneficiaries. The beneficiaries are named
Thank you.
for 2 children.
Right. So for all of the trust assets, the advice is legally correct, okay? Because I do that for some of my younger clients, right? If I think there's a possibility that my clients are going to have additional children, I'll just say split evenly among all surviving children, because unless in the unlikely event you intend to disinherit one of your children, then it's just an open class. However many children we have, that's how many ways it gets divided, okay? On the other hand, people like myself who have a 14 and 11-year-old son and we're done having more kids, I just say divide it evenly, 50-50 between Grady and Hudson. I'll identify them by name, okay? So that part is legally correct. The problem is the retirement assets, okay? If we go back to the hypothetical, we have a situation where we have the non-owning spouse as primary and then Alex and Benjamin as the backups, contingent beneficiaries. If we do not add Celeste, she's not going to get any of the retirement benefits, okay? That's why it's very important to make sure that beneficiary designations are in compliance with the estate plan unless they are intentionally not in compliance. I'll give you an example of the second one, okay? I have a lot of clients who come to me and they say, okay, I want my assets divided evenly among my children, but I want my grandchildren to get something, okay? And what that something is can vary, of course. But again, in that situation, we can list the grandchildren as separate beneficiaries. We're doing that intentionally. We're not having it, we're purposely having it be different from what's in the trust. But for the most part, we want the beneficiary designations to mesh with the trust. I'll give you another example that those of you who've attended lunch and learns before have heard me say before, but it doesn't hurt mentioning it again, okay? To demonstrate the importance of listing appropriate beneficiaries, okay? This is kind of a one-off from what we have here. I get married, okay? I list wife 1 as my beneficiary on my 401k through my employer. I get divorced. I list wife 2 as my subsequent beneficiary on everything else, but I never update my beneficiary designations on my original 401k. I die. Wife 1 gets that money, okay? I can update my estate plan. My estate plan can say everything to wife 2. It doesn't matter. The beneficiary designations are always going to supersede what is in an estate plan. That's why it's very important to make sure that there is an overlap. And that's one of the reasons we work with entities like Client First. We work closely to make sure that the beneficiaries mirror what they should be as it relates to the estate plan. So again, it's like 85% correct legal advice, 15% incorrect legal advice. So now we're going to move on to Stacy with powers of attorney for young adults.
My name is Monica. I have 2 daughters, Chloe and Danielle. Chloe is starting her junior year of college, and Danielle is about to start her senior year of high school. Danielle will also be turning 18 in a month. I have been reading online that colleges do not inform parents if their child is injured. How can I avoid this? And with Danielle going to college soon, what benefits do I have?
Well, most colleges have parental forms that you can sign that allows parents to have access to that information. That's good enough. Same would apply to Danielle. She's living in your home, there's no issues. Just make sure you sign a similar form when she leaves to go to college. Green if that's good advice, red if that's bad advice. People have been listening to my seminars. I am glad because in my radio shows, because literally every time I'm on the radio, this is what I talk about. So basically, a couple issues here. One, college permission forms aren't applicable if you're off campus. A lot of college students will go off campus. They'll go to a game. They'll go to a restaurant, whatever the case is. That college permission form is not going to supersede what is in a power of attorney. The statement I make all the time is that every single person over the age of 18 should have powers of attorney. Why? Because every single one of us, regardless of age, regardless of health, we're all one moment away from incapacity. Bad moment behind a wheel, sudden onset of a disease. We can go from being perfectly lucid and perfectly capacitated to permanently incapacitated in a matter of a second. And the only way we can do that and avoid that for our 18-year-olds is if we have a power of attorney. Now, statistically speaking, most 18-year-olds in the state of Wisconsin live at home. Most 18-year-olds are still seniors in high school at that point in time. So a lot of people will incorrectly believe that if they're 18, they're still a senior in high school, they're living at my home, we as parents can receive that information and make those medical decisions. No, you cannot. The moment they turn 18, we need to have those documents in place. The reason I highlight the college example is because this is by far the month where I do the most of these powers of attorney, because a lot of people have the foresight to think, well, gee, Junior's going off to college, we need to make sure we can access something with Junior. And that's correct, but it's not the whole story. The whole story is the moment a child turns 18, we need to have this in place, okay? And again, to be clear, a lot of people are very surprised by this. I talk about the polling 100 people at Walmart. If I polled 100 people at Walmart and asked them this question and said, hey, you have an 18-year-old senior in high school and you find out that they're incapacitated, can you make those medical decisions? Can you find out information about their condition? They'd say, absolutely, it's my child. They live under my roof. My favorite one, they're under my insurance. None of that matters. It is a black and white standard. You are either under 18 or you're over 18. And if you're over 18 and you don't have these powers of attorney, information cannot be conveyed. Now, to be clear, okay, I am assuming incapacity. So if that same 18-year-old gets in a car accident with a broken leg, they can communicate to the doctors, hey, call my mom, call my dad. That they can do. But if the accident is such that they don't have capacity, the hospitals can't just assume that that information would want to be, they want that information shared with their parents. So again, I just want to make sure we're clear on what the standard is. But again, what I always tell my clients, this is a common theme that I repeat throughout my practice. The likelihood that a particular 18-year-old will be in this situation is low. And that's a good thing. We don't want our 18-year-olds to become incapacitated. But here's the reality. It's not 0% either. It's somewhere north of 0, and that's the whole idea behind estate planning, particularly for powers of attorney for young adults. And it is a very quick, easy, and inexpensive process. So again, maybe a lot of you don't have children who are around the age of 18, but maybe you have some grandchildren who are nearing the age of 18. You ought to let your children know that their children need to have these powers of attorney in place the moment they turn 18. All right, we are now back to Shannon.
My name is Muriel, and my husband is Ronald. I know I don't look it, but we recently turned 90. Many of our friends have already taken care of their estate planning, but we've been procrastinating. Now we've heard that because of our age, there's nothing we can do. We have heard something about a 5-year look-back period. We don't know if we're going to make it another 5 years. So are we just out of luck?
You're not out of luck, Muriel. There's a lot of things that we can do to help people who are at this stage, regardless of the timing that they're at. If it is prior to your passing, we can do that. Most estate planning documents are not subject to a 5-year look-back period and go into force and effect the moment they are signed. Thumbs up if that's good advice, thumbs down if it's bad advice. I really need to make these more challenging next time, so I apologize. All right, so the answer is this. Basic estate planning documents go into effect immediately. Now, you have to have capacity, of course, right? I mean, if some people don't have capacity, we have that, what I call the battle against the clock. If I get a call from someone who's not doing so great and their condition is deteriorating, we may get to a point where I have to say, well, wait a minute, we have to make a determination on capacity, because obviously we cannot execute documents if somebody lacks the capacity to sign them. So that's pretty straightforward. But assuming capacity, there is no look-back period on any documents. Now, where does that look-back period come into play? It comes into play when it comes to what the state calls estate recovery, okay? Estate recovery is the concept that certain assets have to be made available to pay for your nursing home care. And there's a 5-year look-back period when it comes to gifting or transferring of assets. What I've found in my practice is oftentimes people conflate the two. They hear people talking about 5 years, 5 years, 5 years, and they think that applies to all estate planning, and it doesn't. In fact, it only applies to a very small subsection of estate planning where there is the attempt, and I emphasize attempt, to protect assets from nursing home estate recovery. That's the only time that 5-year look-back period comes into play. If we're talking about powers of attorney, whether they're financial or healthcare, if we're talking marital property agreements, if we're talking wills, if we're talking revocable trusts, those are not subject to any sort of look-back period, and again, can be accomplished, created, and enforceable the moment that they are signed. So the issue is that it's never too late to do that. Furthermore, even if we are concerned about nursing home estate recovery, there are many non-legal ways that we can accomplish that are not subject to a 5-year look-back period. To be clear, I said non-legal, not illegal, non-legal. What does non-legal mean? Something that someone other than an attorney completes, okay? So there are things that can be done, such as making a home more accessible, putting in ramps, expanding showers, things like that. Spending money on things for yourself that will make your life more comfortable. A newer television. I just bought my dad a couple weeks ago a power recliner. Things like that. Those are perfectly acceptable and not subject to a 5-year look-back period, okay? So that's important to know. So if you are in that situation where you think it's too late, it's never too late. It's only too late the moment you've passed away or you've lost capacity. Other than that, there are definitely things that our firm and other firms can do to assist you in making sure that your plans, your money that you work hard for, goes to the people and the causes you want it to go to with minimal time, cost, aggravation, and governmental interference. That's what we do on a daily basis. Guardianship of minor children. Taylor.
My name is Olivia. I have 2 children, Ella and Finley. My husband and I recently worked with you to complete his parents' trust. We saw you at the county fair and saw that you stated that anyone who has minor children should have an estate plan in place. That can only be for wealthy trust fund children, right? My husband and I worked hard, but we are firmly middle class. It clearly is not necessary that we need to have an estate plan, but we just want to make sure.
It's good to see you, Olivia. But everyone with minor children should have an estate plan in place, because an estate plan is the only way to guarantee guardianship of minor children in the event that both parents pass away. Thumbs up if that's good legal advice, thumbs down if it's bad legal advice. All right, again, we're going to go to the drawing board and make it a little harder next time. So, yes, that is correct legal advice. And what it really comes down to is this. I will tell you, as a first-generation lawyer, this is one of the things that kind of surprised me the most, that people just generally aren't aware of this information. A lot of times when I express it to people, they just don't agree with me. And not that I'm a lawyer, I know everything, but at the same time, I am coming from a position of having done this for a while. Still to this day, people will come up to me and say, well, we have a notarized letter that says our parents get the kids, or that godparents get the kids. My response to that is that's completely legally unenforceable. It's not worth the paper it's written on. I will tell you point blank, unless guardianship determinations are made in a legally valid will or trust, they are useless. They are absolutely worthless. A court is going to determine guardianship of minor children, okay, if we don't have it written down. Now, what does that mean practically? What that means practically is you're going to have a bunch of attorneys who are going to try to convince a judge that their client ought to be the one who gets guardianship of the minor children. And I can tell you both from personal experience as well as professional experience, the most important thing about nominating a guardian is deciding who is not going to be the guardian, okay? I know that's cynical, but I can tell you for a fact that is what I've run into constantly in my practice. And the problem is this, there tends to be a pretty strong correlation. It's not perfect, but a strong correlation between the less great you feel about somebody serving as guardian and how forcefully they seek guardianship, okay? So what they're doing is they're convincing a court. And what is a judge to do? A judge is simply trying to do the best he or she can do based upon the arguments presented by the attorneys, maybe testimony of the children if they're old enough and competent and everything else, to make a life-altering decision. My premise is simple. Who better than the parents to make that choice? We have a lot of parents in here, okay? I don't know how many of us have children under the age of 18, but again, I'll bet you have grandchildren under the age of 18. And it's very important that we make those guardianship determinations or let people know that, hey, estate planning is not just for the rich. It's not just for the elderly. It's for anybody who has children under the age of 18 because, again, the money is what it is. We're going to talk about probate and trust in a little bit, but I can tell you, as a parent, not as a lawyer, but as a parent, by far the most important decision I can make is who gets Grady and Hudson if my wife and I pass away. There's nothing even close to the level of importance other than that. And what I try to do in my practice is stress the importance of that because so many people just ignore it. So many people are just tangentially aware of it or they're willfully ignorant as to what can allow somebody to be able to determine guardianship. A lot of people just think godparents do it. That's a creature of religion. I'm not saying it's not a good thing. It's a wonderful thing. But that godparent can't go into court and say, well, I'm the godparent. I get the kids. Does not work that way, okay? If we want it enforced, if we want it to go correctly, without court intervention, without the guesswork of who a court might assign, it needs to be in either a will or a trust. My final point on this is that, and again, this is one of those things you just learn in practice, I would say a little less than half, but probably more than a third, of my clients who have minor children elect to have a non-family member serve as guardian. Why, you may ask? Well, it's family friends. It's people who have 8 children who are aged similarly. Maybe the kids go to school together, they play sports together, they go to church together, whatever the case is. They may be a better fit, just from a time standpoint, than parents who are older. So therefore, they pick non-relatives to serve. And that non-relative has basically a 0% chance of going into court saying, I know we have this whole cavalcade of relatives here who want to serve as guardian, but the deceased really wanted me to do it. So if that's your preference, that's even more of a reason to make sure that it's memorialized through either a will or a trust.
When I work in a nursing home,
Sure.
assisted living, and
Yeah.
we've got like 3 individuals that actually went out and got a guardian at Lytton.
Yes.
Because the family members were fighting.
Yes.
How do you go about getting a guardian at Lytton?
Good question. The question was, how do you go about getting a guardian ad litem? So full disclosure, I farm out all of my guardianship work, okay, when it comes to that. I mean, I draft wills and trusts that allow you to nominate guardians for minor children. The guardianship you're seeking is the guardianship of what they call an alleged incapacitated person, okay? That's the phrase the state of Wisconsin uses, an alleged incapacitated person. And it's just that. I guarantee you every single person in this room has heard the phrase innocent until proven guilty, right? When you hear it on the television, even the guy, in Waukesha where they had videotape, doing what he did, he's still an alleged criminal until he's convicted, okay? That's the hallmark of our judicial system, right or wrong, okay? Same thing in this context. If somebody brings a petition to the court saying that John Doe is incapacitated, well, until he's proven incapacitated, he's an alleged incapacitated person. A guardian ad litem is someone who's appointed by the court to interview that alleged incapacitated person and draw their own conclusions. Because, I could be upset with my mother and call and say, she's incapacitated. They don't just take my word for it. They need a neutral party. It's usually an attorney. Most guardian ad litems are attorneys. They're at least court appointed to interview that person, and they would provide testimony at a trial to determine incapacity. So that's how you go about getting a guardian ad litem. It's a court procedure. Okay? Very good question. All right, next up we have Stacy on funeral trust planning.
My name is Bernice, and my husband is George. 5 years ago, we set up our estate planning needs. We know that funeral planning is important, and we want our trusted attorney to prepare one for us, just like he did 5 years ago. We just want our final wishes memorialized, and we each have a life insurance policy to cover funeral costs. Can you help us?
It's a very prudent plan, Bernice, but I can't provide help with a funeral trust directly. These are not documents that an attorney drafts. I can, however, provide you with the names and numbers of entities who can create a funeral trust for you. As far as end-of-life decisions, there are state forms that can be filled out that can help you indicate what you want and what you don't want as far as end-of-life decisions. But unfortunately, as an attorney, no, I do not draft funeral trusts. Thumbs up if that's good legal advice, thumbs down if it's bad legal advice. Okay. So here's what I can tell you, all right? So this is generally good legal advice, okay? I can tell you that. There are some attorneys out there that draft funeral trusts. I myself don't. Funeral trusts are basically insurance policies that are guaranteed to pay out a certain amount of money in the event of passing, okay? Now, the life insurance policy, that's the part where I want to clarify here, because I didn't specifically speak to that, okay? A common misconception that I run into with my clients is they incorrectly believe that life insurance is good enough to pay for final expenses, okay? I'm not going to take a poll. I'm not going to require the thumbs up or thumbs down, but I guarantee you, based on the size and the age of this audience, there's at least one person in this room who still thinks, I have a life insurance policy and I got it to pay for my final expenses, okay? Here's the problem. If you need nursing home care to be provided for by the government, they will require you to cash in that policy to pay for your nursing home expenses, okay? So it's not a guarantee. It's a possibility. It could happen. You could end up not needing care, and then sure, they can use it. The problem there is you list human beneficiaries, okay? You list your sons, Huey, Louie, and Dewey as beneficiaries, okay? Because you're dead. You can't use it. Huey, Louie, and Dewey may use it, but they're not required to. Or in some family situations, Huey feels, you know what? I took care of mom and dad while they were alive. My brothers are going to pay for the funeral. I'm keeping my share. Happens all the time. How do we avoid it? By creating a funeral trust. Why am I a fan of funeral trusts? Because it is a given. There are so many things in my practice that are unknown. We don't know how long we're going to live. We don't know what kind of condition we're going to be in. We don't know if we're ever going to be incapacitated. We don't know if we ever need to go to a nursing home, how long we need to be there, whether or not we need the government to pay for it. All of those things are unknown. There are two certainties in my practice, okay? One, we're all going to pass away at some point. It's a given. Secondly, nobody passes for free. I don't care what your religious beliefs are, what your personal preferences are, nobody passes away for free. We need to make sure that we have that paid for. So funeral trusts allow us to set aside a sum of money that will cover those expenses. Now, depending, again, on personal religious preferences, whatever the case is, that may raise or lower the amount we need to have in it. But having it set in a funeral trust allows it to be guaranteed. It allows it to be protected from nursing home estate recovery. Because again, if we get to that situation where we spend all of our money, the government's paying for our nursing home care, they're not going to pay for the funeral. Social Security pays $255 towards a funeral. Okay? That's it. The rest has to be made up somewhere. So what I always encourage my clients to think about is to make sure that it's done appropriately and prepaid for, because this is, again, an event that we know is going to happen. No chance that it won't happen. All right? The other idea is this. The question I get is, should I go to a funeral home? You see funeral homes, they offer similar things to what we have here, lunch and learns, where you can learn about how to prepay for your funeral. Here's my only caution with that. We don't know whether that funeral home is going to be in business at the time we pass away. We don't know if our child is going to end up getting a job at a competing funeral home and we want to go over to that funeral home, okay? We don't know if we're going to stay in Wisconsin. I saw a lot of reds when I said winter's better than summer. A lot of people prefer the summer. Leads to snowbirding. I have a lot of snowbird clients. They get old. They don't want to be in the cold anymore. What happens if you move to Florida or Arizona and you've already prepaid for your funeral here? It's a big problem, okay? Funeral trusts, on the other hand, prepay for all of that. You can take it anywhere. It pays out within 24 to 48 hours. So again, I have clients who are loyal to their funeral home. That's great. Just like with anything else in the entire practice of law, my job is not to tell my clients what to do. It's not. You're my boss, okay? My job is to let you know what the pros and cons are of either doing something or not doing something. That's my job, and that's what I'm explaining with the funeral trusts. All right, next topic. Shannon, out-of-state documents.
My name is Jane. I recently moved to Wisconsin from Arkansas. 10 years ago, I created an estate plan there in Arkansas. I have a will and powers of attorney. My friend told me that these Arkansas documents are invalid, but that makes no sense to me. Legal documents are legal documents. How come I can travel from state to state, but I have to change my documents when I move here?
Jane, I get that. But 50 states have 50 different sets of laws. What may be applicable in state A may not be applicable in state B. Therefore, I will look at your documents, but it's my strong recommendation that we update the documents to make them enforceable in the state of Wisconsin. Thumbs up for good legal advice, thumbs down for bad legal advice. Yep, that is correct. That is good legal advice. I run into that frequently. A lot of our friends from the state of Illinois decide they come to their senses, they move up here. I'm in that boat, but I didn't have a choice. See, I was born in Maywood, Illinois, suburb of Chicago. So my parents had the good sense to move up here, so I can't control where I was born. But a lot of people move up here and, disavow the Bears as their team and, get smarter and cheer for the Packers. But at any rate, they're not forcible. If you look, I have yet to see a power of attorney from any state that does not reference that state's statutes. Not once have I seen it. Wisconsin's do. Wisconsin's powers of attorney talk about the applicable areas of the law that apply to powers of attorney, so too do other states. Well, clearly those documents and those laws don't apply in Wisconsin. So it is correct that traveling between states doesn't matter, but if you establish residency in another state, we need to be aware of that and make sure that those documents are compliant under Wisconsin law. The other thing is certain states have different laws when it comes to the enforceability of documents. A common example is this. I learned this a couple of years ago. As of a couple of years ago, and I don't stay abreast of North Carolina law all that often because I don't need to, but I had a client who presented some North Carolina documents. In North Carolina, apparently, you only need one witness for any trusts, powers of attorney, things like that. Well, in Wisconsin, you need two. So even if there were no statutes that governed how that was set up and specifically mentioned in those laws and in those documents, well, the fact that North Carolina has a different set of rules about the number of witnesses than Wisconsin does makes them unenforceable here. Wisconsin, you got to have two witnesses. So that's just one example. So again, if you have out-of-state documents, it's a good idea to have them reviewed by a Wisconsin attorney, and he or she can indicate what can be salvaged and what cannot, because there's certain documents that can be salvaged. And the example I give is this. On a little personal level, my wife hit a deer yesterday. Okay? She's attracted to deer. I don't know what it is. This is the third deer she's hit. And she's a good driver. I'll admit, she's a good driver. I'm not going to throw her under the bus. And what's actually, kind of funny, I guess, if you want to call it funny, she told me the story. And I don't know if you guys are familiar with the road construction going on I-43 between Brown Deer Road and Grafton. I don't know if you guys are familiar with that. Okay. Oh, yeah. So anyway, long story short, she texted me and said that she hit a deer. Not too much damage to the car, still drivable, everything else. But she described how the deer jumped over the median and kind of hit the front passenger side of her car. On the way home from my football practice yesterday, I saw the deer. So I know she was telling me the truth. I know where it happened. So I guess my point is that, again, when it comes to that kind of story, I guess I don't really have a point. But it's kind of an interesting anecdote, right? I totally forgot where I was coming from, if I'm being honest. I just wanted to tell a story about my wife hitting a car, or hitting a deer, so I apologize for that. All right, moving on. My errors don't need to become your errors, so we'll just go from there. I just thought it was a cool story. All right, supplemental needs trusts. Taylor.
My name is Mira, and I'm a single mother. I have 2 adult sons. Alex is married with children, but Benjamin has Down syndrome. As a mother, I want to treat my children equally, but I heard that if I give money to Benjamin, he may lose his governmental benefits. He needs that money to make ends meet, particularly after I pass away. Is there anything I can do?
I love the accent here. That's impressive. I was thinking of doing my fancy lawyer accent, but I'll just stick with me. Dance with the one who brung you, as I like to say. So we're good there. And yes, this is a difficult situation. You are correct that Benjamin may lose his governmental benefits if he receives inheritance. The way to solve it is simple. Leave everything to Alex. Benjamin's his brother, and Alex will take care of his brother. Just let me draft the documents, leaving it all to Alex. Yeah, that is obviously incorrect legal advice. Now, what I will say is this. I always present that to my clients as an option, okay? And I always tell my clients, just because I make recommendations does not mean they're good or bad recommendations. They're recommendations. I will give you my opinions on them. I'll explain the pros and cons to them. But the idea is this. Broadly speaking, there's 3 possibilities here, okay? Option number 1 is that Mira can just say, half to Alex, half to Benjamin, okay? Well, Benjamin's going to lose his governmental benefits if we do it that way. So that's by far the worst of the 3 options. Second option would be exactly what we described. Leave it to Alex and hope that Alex does right by his brother. Well, hope is a good thing, but it's not a guarantee. The third and best option is to create what's called a supplemental needs trust. Okay? A supplemental needs trust allows Benjamin to have use of the money without having either access or control over the money. Those are the key words, access and control. If the recipient of the governmental benefits has neither access nor control over the money, it doesn't disqualify him from the use of the money. So we appoint someone to serve as the trustee for the supplemental needs trust so that Benjamin can get the benefits of having this in place without any of the downside of having it in place. So supplemental needs trusts are something that I draft frequently. Okay, I probably drafted, I'd say, between 100 and 150 of them during my legal career. So if we have a child or a beneficiary of any kind that is receiving those governmental benefits, it's important that we consider the creation of a supplemental needs trust to make sure that they can receive the money without having access or control over the money. Because the last thing we want, of course, is for them to lose their governmental benefits. And they will, again, dollar for dollar lose those governmental benefits if we do not have a supplemental needs trust in place. All right, final hypothetical. Wills versus trust. I saved the best for last. Go ahead, Ethel.
My name is Ethel. My husband is Dennis. We've been working class during our entire lives. I was a teacher, and Dennis worked at a factory. We both retired 2 years ago. We own our home, and we worked hard and paid off the mortgage just before we retired. We have about $100,000 in retirement assets. We know getting a will is important, but we put it off. Some of our more well-off friends have created a trust. We don't need that, though, do we?
So Ethel, I'm a little confused. Ethel. You started out with a little southern twang. And I appreciate the effort, but you reverted back to typical Wisconsinite that I know we all are. But
Wisconsin longer than in Arkansas.
It's a hybrid accent.
so it ebbs and flows, I suppose. Very good. Well, either way, the effort is wonderful. Congratulations on the retirement. You're correct. A will-based plan is sufficient for you. Trusts are only for wealthy individuals or people with unique situations. I will happily draft a will for you and Dennis. Thumbs up if good advice, thumbs down if it's bad advice. Yeah, you guys have been working with me and attending these lunch and learns long enough, okay? I will admit that it is a common, extremely common misconception. The idea of wills are good enough. I hear that all the time. And the problem is that most of the time they're not. Or if they are, we don't know whether they're going to be good enough until death. That's the moment we know, because the way the law works is this. If we take a married couple and we fast forward to the day the second of the two of them pass away, if there are more than $50,000 worth of probate assets, that estate goes to probate if we only have a will. So where do we start first? Equity in one's homes. Most people have more than $50,000 worth of equity just in their home, let alone before we get to any other assets. If we have somebody who has more than $50,000 worth of equity in their home, they pass away, they only have a will, the estate goes to probate. Now, can we list beneficiaries? Sure we can. Do beneficiaries guarantee that the estate avoids probate? The answer is maybe. Now, what I've learned is this. In my 17 years of practice, there is no word that makes my clients more upset than the word maybe. Okay? But I will clarify it. The reason it's maybe is because we don't know. We don't know whether those beneficiaries we list are going to survive us. Take my situation. I have two boys, Grady and Hudson, 14 and 11. They're a generation younger than me. They should survive me. I want them to survive me, but there's no guarantee that they survive me. The trust, on the other hand, has a 100% chance of surviving me because the trust can't die. So that is why I'm a fan of trust-based planning. It gives us the guarantee of probate avoidance as opposed to the high likelihood of probate avoidance or just likelihood of probate avoidance. Why is probate such a bad thing? It boils down to three reasons. First is cost. Average cost of probate in the state of Wisconsin, between $5,000 and $10,000. Second is timing. Average length of probate, 12 to 18 months. Third reason, public record. Wills become public record after somebody passes away if it goes through probate. Not only does the will itself become public record, but the amount and the character of the assets that pass through the will also become public record. So to be clear, the only two ways we can avoid probate. Way number one, we pass away with less than $50,000 worth of probate assets. Then a will is fine. But if we have more than $50,000 worth of probate assets, the only way we avoid probate is to create a trust. So I'm a big fan of certain outcomes, and I explain that to my clients as well. The trust creates the guarantee of probate avoidance. The will may or may not avoid probate, but the problem is we're only going to know that certainty once we've passed away. So that's why I'm a big fan of trust-based planning. Yes, sir?
If you have a trust, do you need a will?
If you have a trust, you need a will. What I can tell you is that under Wisconsin law, we need to have something that identifies the existence of the trust. So what I do is I create a very basic will that says, see the trust for distribution. So I do recommend having one. Yes, sir?
We have certain items you want to go to people.
Yep. It can be done through a trust. It can be done through a will too, but you can specify in the trust. You know, I want it divided a third, but I want my son to get my Camaro. I want my daughter to get my motorcycle. Whatever it is, you can specify those accordingly in either a will or a trust. Very good. So that is the end of my presentation. Can we just give a quick round of applause to my three paralegals here? They did a wonderful job as actresses here. But I am happy to answer any questions subject to Paul telling me that I have to get off the stage.
Although it's complicated.
Uh-oh.
So you often reference state law whenever you're talking about trusts or wills or anything else. Is there anything in federal law that we need to be thinking about or concerned about?
Other than the federal state tax threshold, no. The federal state tax threshold right now for a married couple stands at $25.8 million. If anybody has more than $25.8 million, we need to chat. Yeah.
We have more than 28
All right, how about a round of applause for Rob, right? All right, you have a feedback form. You can do it one of two ways, using the QR code or the paper form there. Yeah, you can hand those in. Heather and Sarah are waiting there at the table, like just where you checked in. Then we have, next month, I'll be up here talking about the latest trends in cybercrime, and there's some really clever ones that are happening now. It's quickly evolving, so I'm going to go through that, and then 10 ways you can actually protect yourselves on that. By the way, how many of you have frozen your credit?
What?
Yeah, how many of you have frozen your credit? If you haven't, you better, right, with that US DOD one. I'll talk more about that in September. Yeah, you can freeze it. Don't lock it, but freeze it. All right. Then, finally, if you need help financially, schedule initial consultation with our team. You know how to get a hold of us with our telephone number or stop by our office. So with that, Rob's available for questions right there in the back along with his team. Oh, yeah. Your thumbs up, thumbs down. The team will be there by the door to collect those as well. I think that's the final thing. With that, we're adjourned. Enjoy your afternoon.